99. లింక్ కావాలన్నా. రావట్లేదు. పేరు
హెచ్డిఎంఐ రావట్లేదు.
నేను ఇప్పుడు వరకు ఆన్ చేసి వచ్చా కదా.
మీరే స్టార్ట్ చేయండి.
Good morning, all. Please settle down. I hope you have done the work which I gave you yesterday. How many of you have done your work? Notice and reply notice. We'll start with that. Huh? Just the notice, okay. Then, how many of you have done both the work? Notice as well as. So, would you like to share with the other people? Share with the other people. How did you draft it? How did you frame the outline for the facts? What are the things that you have to see before drafting a notice? Could someone come forward and explain? Yes. Because 26 teams have given their names for moot court competition, and at the end of the class, I'll briefly describe about what all. Like some people have asked last class they couldn't hear what I was explaining about moot court, so I'll explain briefly, and I'll give you the moot court problem. So, is coming forward and explain me about the notice. Third row. Sure. You did the notice, right? What was the concept? What was the things that you have to see that before sending the notice? First thing, notice. എങ്ങനെയാണ് ഡ്രാഫ്റ്റ് ചെയ്ത് തുടങ്ങിയത്? ആ. ആ. Is it rectify it or you want to edit it? What was the question that I gave you? We are not in the intention to continue it either. So, what's the first thing in the notice you write? It's your name, your address, from whom it has been sent to. Next to whom what? Next paragraph what you should write. Next thing. Yes. Can you read out what you read? Okay. And so first, what you have to do is, in the first paragraph, you have to give only the instruction. That is under the instruction of accident, son of so and so, residing at so and so. I am issuing the following notice to you. That is in the first paragraph. What you said right now is should be in the second paragraph. Okay, okay. Yeah. Carry on. On the date of
email data what the and has expressed its resentment to you by this products and yes, really simply the party let's say which is within 2 months.
Within 2 months, okay.
So you also stated that the property should be inspected by all the legal parties, and once there is no once it is considered that there is no damage, that tax payment given all the payment given to the
Paid back to the landlord. Oh, the advance receipt. Okay, okay. Should be given to the tenant.
after these 2 months.
Okay.
That, and so this guy is particularly violated any of this, but he's still willing to go on.
Left to your imagination, all the things.
That is basically
Then how did you conclude the notice?
fail this issue. My client is willing to go legal that he's willing to file all the way to
Please be silent or at least listen to him.
after this is all set use the topic that is client
Very good, very good. I'm happy at least one person followed the class. Then what about reply notice? Someone from the girls' side. Lot of heads down when I said someone from the girls' side. Please, could you please come forward? I'm not able to follow my classes because few people suggested that I'm taking class very fast. They're not able to follow me. Is it okay? Then what about reply notice? At least give me the structure of reply notice. Yes. Come. Please, no issues.
reason unleash விட அதான பிளான் பண்ணி
Just explain to the class. Wow, very good.
விடையில என்ன சொல்லுன்னா என்ன ரீசன் இருக்கு வேலை காலி பண்ணி ஏன்னா என்னோட ஒய்ஃப் அந்த அவனோட ஜாப் வந்துட்டு இங்கே தான் இருக்கு இப்போ ப்ரெசென்ட்ல காலி பண்ண முடியல ஆனா எங்களால் வந்து லீஸ் சப்போர்ட் பண்ண முடியும்
You want to renew the lease? Renew the lease. Renew பண்ணணும்.
அதுக்கு ரெண்டு இல்லை நான் லீஸுக்கு தரோம் கவுண்ட் ஆகும் என்னால லீஸ் 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 7 லேக்ஸ் சப்போர்ட் பண்ண முடியும் நீங்க கொடுத்தீங்கன்னா நான் லீஸ் கொடுத்துருவேன்
Can you explain to the class? புடிங்கிற வரைக்கும். Even if it is Tamil landlord. Just listen to him, okay? Then I turned mute to the other system also, okay? It was like echoing. What about the date? Subject has to come first, then comes the reference. So you are here, you are admitting the landlord-tenant relationship. Okay. Hmm. Deposit. Hmm. So how many time period you have asked for to payment? 2 months time. Okay, very good. So that is about no reply notice and reply notice. I hope everyone are like familiar with it. Okay, right. You're clear, right? Everything's right. Okay, right. With regard to notice and reply notice. Now we'll move on to what is pleading. Okay. What do you mean by pleading? Huh? What in plain and written statement? Plain and written statement or plain or written statement? Either plain or what is it? Is it plain and written statement? Plain or written statement? Is it plain and written statement? Plain or written statement? Is it and or? Why is it or? And means plain and statement both combines becomes a pleading. No. Plain alone it's a pleading. Written statement alone is a pleading. Both are pleadings. It could be plain, it could be written statement. Okay. So whatever we pray for, whatever relief we need for, whatever the cause of action, whatever be it, that we ask either in the form of plain, either in the form of written statement, or either in the form of any other petitions, it is known as pleadings. Okay. You're now familiar with CPC, right? So shall we just brush up some ideas with regard to AC? In under which section does it says about institution of suit? Section 26 and along with order. What does that order 4 says about? Institution of begins with the presentation of claim. So while if you want to institute a suit or case against a person, the first mandatory thing is you have to find the claims in duplicate before the court. And order 6 is what is the foundation of claims as well as written statement. That is with regard to the pleadings. In order 6 rule 1 actually defines what is pleading. Pleading shall mean Plain or written statement. It can be plain alone. It can be written statement alone. Not plain or written statement. It is plain. Not plain and written statement. It is plain or written statement. Now, while drafting either the plain or either the written statement, few factors has to be kept in mind. That is what we'll discuss today. And tomorrow, because we have to wind up our class by 10:30, before that I have to state about the memorial as well. Today, in brief, we will just see what are the factors that has to be looked into before drafting a plain as well as a written statement. Okay. First thing is, you should state only the material facts that has to be needed. No evidence shall be mentioned in the state in the pleadings. Okay, that is as per section 10 of Indian Contract Act, or section something of act. He has violated some breach or made any kind of breach. Such things need not be stated in the plain or need not be stated in the pleadings. Just the material facts has to be stated. This is said under order 6 rule 2 of CPC. Clear? Then, the important factor that has to be mentioned here is, at the back, could you please be silent? Next factor is, each and every point or each and every thing that we mention must be paragraphed and must be in number. It should not be like an essay of whole one full page of. Yes, ma'am. Ma'am? Don't know, ma'am. I don't. Uh-huh. Tell. Volume at the back. People at the back cannot hear. At the back, can you hear me? Yes or no? Thank you. It's off, it's off. Yes, like first we have to mention the what? In plain or whether in the written statement, we need to mention only the material facts, but not the evidence that has to be. No evidence has to be adduced during the while drafting the pleadings. Second thing is, whatever contents that or whatever information or whatever things that we are drafting must be paragraphs, must be in number and must be in paragraph, and it is very important. Why? Because in plain, if we in first paragraph, if we mention that the defendant or the respondent has borrowed some money from me, so and so. If the respondent wanted to deny it, it will be easy, and we can say that the contentions or the arguments raised by the plaintiff in paragraph 1 is denied by the respondent or denied by the defendant. So in case for the matter of denial, make it easy for you to arrange. That is why it is mandatory that you have to arrange it in paragraphs and it must be numbered. Okay. So the first thing is, material facts must fully be stated, does not state any kind of evidence in it. Secondly, must be in paragraphs and it must be numbered. Then if you are relying any kind of documents or if you are relying in any kind of contract or anything, mere statement of fact should not be there. You should give some details. Why, for example, if it is a sale deed, you are filed a suit for declaration of the sale deed, or you want to cancel the sale deed. The suit is for cancellation of the sale deed. You should specifically mention when and where it was registered, under whose name it was registered. Some information with regard to the document has to be mentioned. Not vague or vague explanation of the thing should be given. Such kind of things has to be taken care, because for that only we are asking relief, right? So such thing has to be we have to make sure it is specifically and clearly it has to be mentioned. Is it clear? Then, be it the plaint, be it the written statement, each and every pleading has to be signed by the party to the suit, each and every party. That means if there is more than one plaintiff or more than one defendant is there, each of them has to sign the plaint on every page. Every page, and at the end of that plaint or written statement, the lawyer or the concerned person has to put a signature. Clear? Even see, this is the plaint and it has n number of pages. Even in n number of pages, at the end of the page, the parties to the suit, even if it is 10 or 20, each party has to sign each, because it is making sure that it is their pleading. It is from that they are pleading before the court. And at the end of the pleading has to be signed by the courts. And the most important thing is verification. What is verification? That you have verified. There are three terminologies that you have to keep in mind. All the facts stated above is in my knowledge, belief, it's true to my knowledge, belief, and information. And it has to be signed by either one of the party or whoever signing it. If it is more than one party is there in the suit, one party is enough to sign the verification. So what is the sentence that you have to write for verification? All facts stated above are true to the best of my knowledge, belief, and information. This is given under section. Sorry. This is given under Order 6, Rule 15, Clause 2 of CPs. I will read that. The person verifying shall specify by reference to the numbered paragraphs of the pleading what he verifies of his knowledge and what he verifies upon his information received and believed to be true. So it is mandatory. If there is no verification, it is a ground for rejection. Because it is important that he has verified. Otherwise, this suit has been filed by the advocate, because it has not been verified by the parties to the suit. So it has to be first the pleading has to be signed and signed by each and every party to the suit, and at the end it should be signed by the counsel appearing on their behalf, and then at the end of it should be signed by it should be verified by any one of the parties to the suit. The party who verifies this has to file an affidavit supporting the plaint as well. It is also mandatory. Once you file a plaint, the plaint should be verified by one of the party, and the party which verifies this has to file a sworn affidavit that the so and so fact about how to write an affidavit. We will discuss in detail in the further coming classes. Okay. So those are the things that. Do you know how to control this sound? Away. இதுமா. Okay. Now is it clear? So far is it clear? So far is it clear? Now is it audible? Is it audible? Can you hear me at the back? And pardon me, I missed the one point in between. Uh, in the pleadings, it is also very mandatory that you should mention the address, because I'll say the one of the format in the plaint. First, we'll write the cause title, everything we'll write, who's the plaintiff, who's the defendant and all. Then, under what section you are filing the suit. Under section 26, read along with order 6, 7, whatever it is. And you have, then you will write in detail about the parties. That is, plaintiff, the age of about this much, son of so and so. And at the, after writing their details, it is mandatory that you have to write the address of the council, or because for the communication we have to write all notices and processes hereafter has to be sent in the above address, or to the council, or to the advocate that he is being engaged with. So it is also mandatory that you have to mention the address of the council or the address of the parties to the suit. These are the factors in short. We have to make sure before drafting or before starting to write a pleading with either the plaintiff or the written statement. Then what we have to make sure is the content that we write. First thing is the relationship, or what is the relationship between the parties, that what is connection between the defendant and the plaintiff. Okay, what was if there is a money transaction between them? If it is a partition suit, they are how did like about their relationship? Then be it if it is a partnership firm with regard to them, and all those things has to be mentioned in the first two paragraphs. That is the storyline. Clear. That is about the parties. And if it is a with regard to a property, if it is with regard to a property, how he acquired the property and every details has to be said. And if it is with regard to any land dispute, the schedule of the land has to be mentioned, and how the parties obtain the property has to be mentioned clearly. Then, then we have to discuss what is the dispute between the parties, and when and where did the cause of action arise. Cause of action means if he has committed any breach of contract. Why it is important? Because in order to determine the jurisdiction of the court, it is mandatory when and where the suit, or when and where the cause of action arose has to be mentioned. Only then we can analyze whether the court trying has jurisdiction or not. So these are the things you have to keep in mind before analyzing, before start. These are the outlines that you have to keep in mind before starting to draft either a plain or a written statement. So far is it clear? Now I am putting your question. Once you drafted a plain or written statement, you have filed also, and the proceeding is going on. Okay, you have learned about res judicata, right? So once you say something, you cannot go behind by it, right? Then, and the suit is in proceeding, and one new cause of action or one new information has come to you, which is very relevant to the fact at hand. Is it possible? And in between, when the suit is going on, is it possible to add those factors while the suit is going on? And if it is yes, under what provision? Yes? Very, very good. Order 6, Rule 70, that is amendment of pleadings. Even during filing, or even before judgment is passed, you have got a right. You have got the right to amend the pleadings. But the pleading has to be amended within 14 days. Understood? And that is dealt under section rule 80. So far is it clear? This is in short order 6. Tomorrow we will be dealing with plains as well as written statement in detail. Before that, 26 teams have given their names for moot court competition. I'll hand over the moot problems to you right now. So what are the queries with regard to moot court? Some people were asking, what is your queries? What do you want me to explain? Yes. Then I'll give you a team. Just find some. We'll talk about it. Moot court பத்தி யாருக்காவது doubt என்ன இருக்கா? Of what? Or is it the oral submission or the written submission? While submitting this is the moot problem, and there are 5 issues with regard to this. Okay, and you have, as I told earlier, once you get this moot problem, please read. Keep on reading unless and until you are thorough with it, because this is a little tricky one and it is an easy one. Once you get the idea of it, it will be very easy. So put your heart and soul, everything into this, and please read the problem. And while reading, you might get a lot of ideas. It has IPC, Constitution, especially Article 25, and some jurisprudential purviews also there with regard to but corporal punishment. Everything is there. Okay. So when you start to research, just download, just read everything. Make it a file, read everything. Later on, I should come out. Students, please cooperate with me because live recording is going on. They couldn't hear my voice, only your murmuring sound and whistle sound is being heard. So please be silent just for a while. Okay. Then once you get the mood problem, just read again. Then next you will get an idea on what all fields you have to do your research. Okay. I'm not telling, this is a constitution based and as well as IPC based question. So find articles, read commentaries, read textbooks, everything, and write down with footnotes, because that is important. What all books you refer, what all articles that you refer has to be mentioned in the memorial, right? So everything has to be, you make a file, write down everything. Then we have to start preparing a memorial. Once you decide which among you who is going to do which issues, each and every one has to be in communicating with each, like all the problems, issues not that first 2 issues will be dealt by the first speaker, so he has to do it alone. No, all the speakers, all the researchers, and everyone has to do in a like if one person, suppose during the moot court competition, like what happened in when Shanmugam went, one of the motor was got sick and the researcher has to step in as a speaker. So, appadi situation varala. Understood? So, everyone has to work as a team. And first the moot court memorial எப்படி இருக்கணும்னா first there should be a cover page. And in that cover page, in the cover page, you have to mention the name of the forum. Okay, before the honorable so and so. That will be given to you. Okay. Next, title of the competition. That also will be given to you. Name of the case will be given to you. That is X versus Y, whatever it is. Then title of the memorial. That is, you have to file, you have to make two memorials on behalf of the plaintiff, on behalf of the defendant also. So, memorandum most respectfully submitted by the plaintiff and submitted by the respondent. Likewise, we have that should be the cover page. Then comes the table of contents. In table of contents, என்னெல்லாம் உள்ள நீங்க ஆட் பண்ணிருக்கீங்களோ அதன் heading மட்டும். That is index of abbreviations, index of authorities, statement of jurisdiction, statement of facts, statement of issues, summary and pleadings, and pleadings, arguments advanced, and prayer. These are the things should be there. Just அது என்னென்ன பேஜ்ல என்னெல்லாம் நீங்க சொல்லிருக்கீங்க. Just the heading and the page number has to be mentioned. Then in detail, you have to write index of abbreviations. What all abbreviations that you have included in the memorial has to be stated in the index of abbreviations. Then comes the index of authorities. What all comes in index of authorities? First one, articles that you have referred to, be it online, offline, whatever textbooks, anything. Then books that you have referred. Then rules and statutes, commentaries, journals, dictionaries, even dictionaries. If you have mentioned even Oxford dictionary also you can mention. Okay. Then international conventions, legal databases or website. That is if you have Hain Online, you use Hain Online or India Kanu. India Kanu is actually not the authorized thing, but still for college mode you can use it. And such thing can be used. Then table of cases. During the memorial, while the formation of memorial, you will refer a lot of case laws. So that case laws with citation has to be mentioned. Then comes the statement of jurisdiction. Whether this court has jurisdiction to try this case or not, that has also to be mentioned. Okay. Once you read the fact, you will understand. You will automatically be able to frame it. Don't worry. Then statement of facts that has been given to you. If you want, you can cut it short again also, but provided you keep all the relevant facts. You should not miss any relevant facts. If you want, you can cut it short. The facts as well. Then you have to. There are 5 issues. All the 5 issues summarized in paragraphs, not more than 2 or 3 sentences. Like whether he is liable to be punished under 302, yes or no. That is enough. Okay. And then you have to write a memorial. That at least should contain around 15 pages. At least 15 pages because there are 5 issues. Okay. For your convenience, you can also create sub issues as well. If you want, you can create sub issues. That is according to you. That is your imagination. We have already framed the issues and given to you at hand. So it is just you have to work on it. Okay. So far is it clear? Then the prayer model is also will be given. Will be given to you. Any more queries? It should be obviously in active speech. Or it should be in formal language. The copies with me after class. Please come and get the 26 teams as well as you. Form a team and come to. Thank you. Come to tomorrow at around 11 o'clock for collection of the moot copy. Okay.
क्या स्वाद है, क्या स्वाद है जिंदगी का, कुछ घास हाँ madam, those who are shouting, misbehaving, kindly take their ID card. Simply tell them to give their ID card. Okay. No, whoever is shouting, whoever is disturbing my class. Yeah, nice. Good morning. Okay, we have discussed it yesterday regarding the formation of the Advocates Act of 1961. We have seen from the charter party charters of 1721, 1771, 26, 1726, 21 till the committee of 1953, culminated into the report which was accepted. So, culminated into the formation of the Advocates Act of 1961. It's a very small act containing of 60 sections, 7 chapters. The citation of the act would be Act number 25 of 1961. Act 25 of 1961. That would be the citation of the act. Now it's short titled as Advocates Act of 1961. 61. With regarding to the constitution of the act, why this act was formulated, if we see the objective and scope of the fair act, go through the objective, it is clearly specified here. The act amend and consolidate the law relating to legal practitioners and to provide for the constitution of bar council at state and all India bar council. So the act has been amended, it has been modified from time to time, it has been brought together for the full sole purpose of the formation of culmination of to make a constitutional body of state bar council as well as all India level a council, that is none other than the bar council of India. Now the act has been established for the sole purpose of a common role. We have seen the main idea behind the formation of the bar council of India was none other than the formation of a unified legal practitioner system, that is a common role. So it has been achieved herein. So common role for advocate was made by this Advocates Act. We were able to establish a common role and they have the right to practice. Who all are enrolled themselves in this particular role will have a right to practice. Yet another topic is right to practice. Who all, no, don't write right to practice law. Who all will have the right to practice law? This is another question which will be asked in part B question. Part B. What are the rights of an advocate? So what, that is another question. Who all acquires a right to practice? Just individual person has a right to practice, or only those persons whose name are being enrolled in the roll kept by the State Bar Council. We will come across those. What are the functions of State Bar Council, functions of Bar Council of India, etc. So the Act has established none other than a common role of all advocates, and thus they have the right to practice in any court, that be Supreme Court, including the Supreme Court. Now, High Court has also the power to make rules. Supreme Court also have the power to make rules. The article of the Indian Constitution, section 34 of the Advocates Act also provides for making rules by the High Court of the concerned states, that who will practice in that particular court. Again, I will give you time for writing all those notes. Now, Bar Council of India, the Indian Council for Legal Aid and Advice versus Bar Council of India. Please note down those cases. The Indian Council of Legal Aid, the Indian Council of Legal Aid, the Indian Council for Legal Aid and Advice versus Bar Council of India. Write down BCI. The court has pointed out that in this particular case, listen, court in this particular case pointed out that the Bar Council have been created at the state level as well as at the central level, which is Bar Council of India. Not only this particular council has not been created to not only to protect the interest of the advocates meagerly, privilege and the rights of an advocate, but it is also made for to protect the litigating public, the interest of the litigating public. Herein we will generally term them as your client. So the public's interest has also to be protected. How do they do that? There are professional misconduct if done by a misbehavior on the part of the advocate. The Bar Council will take action against you. You are doing something which is against the interest of your client, none other than the litigating public. Hence, this particular act also tries to protect the interest of the litigating public by ensuring that high and noble tradition are being maintained and followed by the lawyers, the concerned advocates. Now, this dignity of the advocates has to be maintained. Hence, it is also said to be that there is a duty vested upon to you, that is the lawyers, the advocates who are so enrolled under the Advocates Act towards the society, towards the public, towards administration of justice.
Now, the Constitution of Bar Council of India, Bar Council, State Bar Council, and all we will come across later on. Provided you just need to understand that there is Bar Council of India in the center and the state bar councils concerned in every states. So the Bar Council of India will have a chairman. Ex officio of the chairman is none other than the Attorney General, Vice Chairman, Solicitor General, and the state concerning the chairman ex officio of the state bar council is none other than Advocate General. Ex officio. Now they will also be elected accordingly. Now there we have State Bar Council, Section 3, functions of State Bar Council, Section 4, 6. We will come across those sections. Provided we will go to another section and we will come back. Now let us see what I have told you earlier. Right to practice. Who has a right to practice? Part B question. This comes under the Part B question. Who has a right to practice? As I asked you, pointed out earlier, does an individual have a right to practice before the court? One question. Second question. What if I personally want to argue my case? Can I do that? Am I allowed to do that? Do I have an inherent right to do so? These are all questions should be answered. Or does the advocates only have the right to practice? Now, practicing as of such to represent another, what we can see is, which we can see from sections of the Advocates Act. We need to go through section 29, 30 and other sections 34 of the Advocates Act. Section 29, let's deal with section 29 of the Advocates Act. I read the Bare Act itself from the Bare Act. Section 29, right to practice, chapter 4. Advocate to be the only recognized class of persons entitled to practice law. That is the title written. So, advocates are the only recognized classes of people or persons who are entitled to practice law. The explanation of section 29. Subject to the provisions of this act and any rules made thereunder, there shall, as from the appointed day, be only one class of persons who are entitled to practice the profession of law, which are namely none other than advocates. Subject to the provisions of this act and any other rules, which means there are certain rules which can be formulated by, according to the section itself. State Bar Council can frame rules. The High Court is allowed to frame rules, according to which they can allow advocates. Meagerly by enrolling, you cannot practice law. Is it allowed? There are committees also. There are State Bar Council, there is Bar Council of India, there are other committees, legal education committees are there. For which now we have to write another exam. Bar Council of India examination, we need to write that exam. Unless until you qualify that examination, you are not allowed to put to Vakalathanama. There are practices are there, but provided it is not allowed, we enroll ourselves, then we write the exam. Now, this examination is another criteria laid down, not by the State Bar Council, by the committee or a body, which is formulated in accordance to the Advocates Act of 1961. So, the section 29 advocates should be the only persons who are recognized to practice law. One classes, this is namely advocates who have enrolled themselves and who have acquired a recognized degree of law from the recognized university under the Bar Council of India. Now, write down another important case, Bar Council of India versus A.K. Balaji. Bar Council of India versus A.K. Balaji, 2018, 5, volume 5, SCC 379, page number 379. 2018, volume 5, SCC, page number 379. The court had pointed out in this, should I repeat? Court had pointed out in this particular case that persons not enrolled as an advocate under the Bar Council of concerned state role, they do not have a right to practice. Okay. It is making it more clear, clarifying section 29. Now the problem arises about a person who have taken degree from a foreign country, or a person who is who is not an Indian, who is a foreigner of another country, who is having a law degree. Can he enroll? He is also possessing a degree of law. Can he enroll in India? This was also laid down in this particular, pointed out in this particular case. Foreigner or a foreign law firm or a company, foreign lawyer cannot practice law in India, either litigate or non-litigation matters. He cannot practice law. Now, there are particular sections which is clearly specifying all these factors. What about I have done my law degree in another country? I being an Indian, can I practice law in India if I come back to India? Another question. A foreigner who is getting a degree is not an Indian, getting a degree from a law university outside India. Can he enroll in India? The answer to this is that it is on the basis of a reciprocity. If our law graduates, Indian law graduates, they are allowed to practice in their country, we will allow them to practice in our country. They are allowed to enroll here and practice law. That is all the reciprocity. I will give you the particular section. Now, section 29, section 30. Please note it down. Section 30. Right of advocates to practice. Section 30. Right of advocates to practice. Subject to the provisions of this act, every advocate whose name is entered in the state roll shall be entitled as a right to practice throughout the territory to which this act extends, to all courts including the Supreme Court, 1, 2, before tribunal or person legally authorized to take evidence, 3, before any other authority or persons before whom such advocate is by or under any law for the time being in force is entitled to practice law. So section 30 again clarifies that a person who has enrolled himself in the state roll is having a right to practice anywhere in India, in Supreme Court, appear before tribunals, appear before arbitrators. These having a authority to appear and practice law as an advocate. Again, Bar Council of India versus High Court of Kerala, note it down. Bar Council of India versus High Court of Kerala. Bar Council of India versus High Court of Kerala. 2004, Volume 6, SCC, Supreme Court cases, SCC 311. In this particular case, as I told you earlier, it was pointed out that High Court is also having a right to frame rules. Please note it down. High Court also is conferred with the power. High Court is conferred with the power to make or frame rules with regarding to the right of advocates to practice. It can decide who will practice before it. It can frame rules who will practice before it. Another case is Jamshad Ansari. Jamshad, note it down. Jamshad Ansari. Jamshad Ansari versus High Court of Allahabad. High Court of Allahabad. 2016, Volume 10, Supreme Court cases, SCC. 2016, Volume 10, SCC 554. Now, it has referred to in this particular case about section 34 of the High Court's power. 34, power of the High Court to make rules. High Court may make rules laying down the conditions subject to which advocate shall be permitted to practice in the High Court and the court subordinate thereto. So High Court is given the power to make rules with regarding to the matter of the advocates to practice before it and courts subordinate to it. High Court of Kerala can frame rules and it can decide who all will practice practice as an advocate before the High Court and courts subordinate to the High Court of Kerala. Likewise in all other matters. So this section is subject to the scope, that is section 30. Section 30, which is the right to practice for advocates before any court, which is including Supreme Court, before tribunals, any arbitrators, for the purpose of giving and producing evidences, etc. This is subject to section 34 of the Advocates Act, and keeping in mind the administration of justice, regulating the court's proceedings, etc. High Court is vested with this power. Okay, so section 29, 30 is subjected to 34. Now, another part which we need to come across is power to enter into compromise without the consent of the client. Now, the advocate is having a right to practice. Obviously, he is entering for the on the basis of a wakalatnama which is signed to him, which is making him appear for his client. Now, once the wakalatnama is given on his name, drafting, pleading and conveyance, you will study about what is wakalatnama, the format of wakalatnama, how wakalatnama is signed, who will sign, who is the witness, who is accepting the wakalatnama, who is signing, who is making this wakalatnama, etc. Please, you need to concentrate. Drafting, pleading, conveyance is a very important subject for you. It's a very important subject for you. I don't mean that professional ethics is not that important. I admit it is not that important, but you need to know, because there are aspects involved in which contempt of court, how you can be made liable for a contempt, what all acts done by an advocate comes within the what all you are not able to hear me. It is ringing. Yeah, I will. So I got distracted. It's okay. That's fine. So what all conduct of yours will be treated as a misconduct for which disciplinary action against you may be taken by the concerned court. What all courts have the authority to take disciplinary action? Does the court have an authority to take a disciplinary action against you, or the State Bar Council only has, and the court will direct the State Bar Council to take disciplinary action against you? Who is the appellant authority against which, before whom you can approach, against whom an disciplinary action is taken by the State Bar Council? Is it the Bar Council of India, State Bar Council, etc.? The Supreme Court India are the matters which has to be seen later. We will deal with those aspects. Now the question arises, power to enter into compromise. It's not working. Something or the another would happen. Hello. I think you can hear me, right? Are you able to hear me? No, this is it's not about this. इसका नहीं है ये जल रहा है ना? Please. Power to enter into compromise without the consent of the client. When the wakalatnama is signed and it is accepted by the advocate, does the advocate has every power or authority to compromise the case where there has no brief, it has not been briefed to him by the client? That has to be seen. Hello. Mic works. Okay. Okay. So this is working. Hello. So whether the advocate is having a power, he can will it lead to misuse of the power? Will it lead to the misuse of his power, where it has not been given an authority to compromise by the client? Now, an advocate has to always be very careful while doing such deeds. Advocate has to, don't look there. An advocate has to always be conscious about this factor, whether to compromise if it is not been briefed to him, if this authority is not given to him. Now, what if he has done in good faith? This is the only way by which at least my client can gain a benefit out of it, rather than prolonging it for another 2-3 years. Maybe the client advocate can do so. So the pleader is not generally, the advocate herein is not generally allowed to compromise for the advocate if it is not expressly stated by the client in the Vakalatnama. Did you understand? So if it is not clearly mentioned in the Vakalatnama that he can compromise, he cannot do so. Now, if he is doing so, what will happen? It becomes unprofessional. It becomes unprofessional, and it is affecting the interest of the client. If it is affecting the interest of the client, naturally there are likely chances that again it can be a professional misconduct for which an action may be taken against you by the State Bar Council. How? The concerned client may file a complaint, may file a complaint against you to the concerned State Bar Council. Now, the State Bar Council, section 3, if we go through section 3, the State Bar Council, we will come across what are the number of members who are selected, how are they elected. If the total numbers are 5,000 but less than 10,000, it would be elected members from among them would be 15. If it is above 10,000, less than 15, it becomes 20, and more than that, elected members becomes 25. Likewise, it goes. Now, from among them, the chairman would be elected. From among them, the chairman would be elected. Vice chairman, likewise. Likewise, in the Bar Council of India also. Now, let us come back to the power to compromise. Regarding that aspect, legal skill hired by the client. Now, the client here, when Vakalatnama is being signed on your name and you as an advocate is accepting, as a client, what am I hiring you for? What am I hiring from you? It is none other than your skill, your knowledge in law. I don't have that. I don't have that. What if I have that, like Subramanya Swamy, Sunanda Pushkar, Shashi Tharoor's case? He argued himself. That is what an individual may answer to the question which I put earlier. At time, the court may allow that party in person. Appear a party in person. So let us come back to this aspect. The legal skill hired by the client herein is nothing other than the legal skill the legal knowledge that you have. What am I expecting? A quick result. I need a quick result. It's not like you prolong my case for a long period of time, and every time the case is called for before the court, maybe the case would be adjourned. Maybe the case, the other party would be not present. Maybe I myself would be absent. Each and every time I will call my client saying that you need to pay 1,000 rupees. For what? Nothing. That happens. Leave those. So, certain circumstances, unless until there is some restriction which is expressly provided by the client to the advocate not to compromise for him, unless until the client briefs him, he cannot do so. So, advocate appearing as a litigant. Let us come to the another point. What if you yourself are the litigant hearing. You have a personal case. Can you appear as an advocate in your case? No, you cannot. You cannot. Note it down. T. Venkanna, Venkanna versus Mysore High Court. It is a 1973 case. That's Mysore High Court. 1973, AIR 1973. AIR 1973. AIR 1973. Mysore MYS. Page number 127. Page number 127. Page number 127. T. Venkanna versus High Court of Mysore. Okay. In this particular case, the court has pointed out, it has clearly pointed out that advocates who are appearing as a litigant in person, he is not entitled to wear robes. Okay, you will have wear a robe, your uniform. What are those? On the blazer, you will have a band, you will have a robes that you wear. You will wear a black robes. Why black? I don't know. I don't know the reason why it is black. I don't know. Maybe. So they wear it. Earlier, you might have seen in the Privy Council the judges wearing a wig. Maybe if it is for me, I can accept that. But I don't know why. Even if, despite they are having long hair, we used to have a discussion on that. I don't know why. Again, we are not following it now presently. So, an advocate, when he is appearing on his personal behalf, he cannot wear robes. He has to remove those, and he has to argue the matter as party in person. Okay, as party in person. Rest of the matter we will discuss tomorrow. Please, silently, you can go for a break. Please be silent. அப்ப நீங்க அட்வொகேட் கிடையாது. நீங்க அக்யூஸ்ட், வந்து அக்யூஸ்ட் ஃபைன் ஆனா கிரிமினல் கேஸ் ஆனா சிவில் கேஸ் சிவில் ஆனா கிரிமினல் எதுவா இருந்தாலும் according to the particular case is predicted down case which you have not the spectrum to the spectrum case. He appointed himself. He argued himself. அவ்வளவுதான். அப்போ நீங்க வந்து அட்வொகேட்ங்க ஆ ஸ்டேட்டஸ்ல அல்ல. Just as a common not supposed to status advocate status. I can argue but not as just a common man. As a your personal status you are arguing that you cannot argue as an advocate. First of all, if you don't know very well, you know the procedures of the law, there is no negotiation. But you, that does not mean that நீங்க வந்து இதற்கு வேண்டி personally appear பண்ணலாம் முடியாது. ஆனா அது முடியும். அது ஆனா கோர்ட் அளவு பண்ணணும். அதுக்கும் ப்ரொவிஷன் இருக்கு. அதான் நாளை சொல்லலாம். அதுக்கும் ப்ரொவிஷன் இருக்கு. நீங்க வந்து you can also appear for another person. Despite you are not an advocate. Despite you are not an advocate. நீ வக்கீல் அல்லாத இருந்தால் வந்து மெமோ கொடுக்கணும் கோர்ட்டுக்கு. நான் போனது இவங்க வந்து கோர்ட்டுக்கு மெமோ கொடுக்கணும். ஏது நீங்க இவர் கூட்டி பார்த்து போறேன். அப்ப நான் அனுமதி பண்ணா ஏன் தெரியுமா? ப்ரொசீஜர் நாவது கோர்ட் இஸ் ஹரிடு. அப்ப இவருக்கு கோர்ட் ப்ரொசீஜர் தெரியலனா டைம் வேஸ்ட். நான் ஏன் வீட்டில நான் கோர்ட் நான் என் பிபி இந்த வைஃப் கிட்ட சண்டை போட்டு வந்திருக்கேன், எனக்கு நல்ல பிபி இருக்கு. அப்ப இவரு வந்து என்ன டைம் if he is consuming at times, I will get angry. Okay, வெளியில போட்டு அலோ பண்ண மாட்டேன். ஆனா I will look whether he is having some potential out there. அது discretion of the court. as a inherent right கிடையாது. ஆனா இதுக்கு வக்கீல் ஆயிட்டு போது இவருக்கு பார்ட்டிங் பர்சனட் அப்பியர் பண்ணணும்னா அது இன்ஹரண்ட் ரைட்டா, அது இன்ஹரண்ட் ரைட் ஆயிடும், அலோ பண்ணலாம். காம்ப்ரமைஸ் பண்ணலாம், காம்ப்ரமைஸ் பண்ணலாம். கன்சென்ட் இல்லாம பண்ணக்கூடாது. அது அன்எத்திக்கலா, அது அன்எத்திக்கலா.
காம்ப்ரமைஸ்க்கே போகக்கூடாது.
காம்ப்ரமைஸ் போகலாம். I am your lawyer, advocate. நான் உங்களை கால் பண்ணி ஒரு காம்ப்ரமைஸ் சான்ஸ் இருக்கு. இப்போ 1 லட்சம் ரூபாய் வந்து they are saying they are ready to pay 80,000. காம்ப்ரமைஸ் போலாமா? ஆனா ஏன்னா நீங்க நம்ம கேஸ் படி லோக்லி நம்ம எக்ஸ்பெக்ட் பண்ணா அப்பொழுது உங்களுக்கு நஷ்டம் தான். அப்ப 20,000 ரூபாய் அங்கே கால்குலேட் பண்ணா 20,000 போட்டல் வெட்டி காம்ப்ரமைஸ் பண்ணலாமா? எஸ், நெகோசியேஷன். அது நெகோசியேஷன்ல போலாம், ஏடிஆர் சிஸ்டம்ல போலாம். இந்த கேஸ் மீடியேஷன் வைக்கலாம். 130 மீடியேஷன் 138 செக்டிஎஸ் மீடியேஷன் கன்சிலியேஷன் மீடியேஷன் கொடுக்கலாம். அங்கே காம்ப்ரமைஸ் பண்ணலாம். அதாலத்துல கோர்ட் சென்சிட்டிவ் அதாலத் மாஸ் கேஸ். ஏன்னா கோர்ட்டுக்கு நல்லதுதான், மைசரேட்டுக்கு வந்து இத்தனை கேஸ் டிஸ்போஸ் பண்ண அவருக்கு இருக்க டார்கெட். இல்லன்னா ஈவினிங்ல ரெஜிஸ்டர் வந்து இன்னைக்கு ரெஜிஸ்ட்ரார கால் பண்ணும், ஹைகோர்ட் ரெஜிஸ்டர் நீ அங்க என்ன பண்ணிருக்க அவர் பிரஷர்.
சுப்ரீம் கோர்ட் you have to write separate examples, sir.
Supreme Court அது கோர்ட் ஆன் அட்வொகேட்ஸ் ஆன் ரெக்கார்ட். இது எல்லாமே ஒரு திடீர்னு கேட்டா நான் என் கிளாஸ்ல சும்மா இருக்கேன்.
ஸ்டேட் தமிழ்நாடு பார்த்து அது வந்து இடையில ஒரு டிஸ்ட்ரிக்ட் இருக்கு, ஹைகோர்ட் போக முடியும். சுப்ரீம் கோர்ட் போக முடியும். இது தனியா எக்ஸாம்
சுப்ரீம் கோர்ட் advocate on record. அது வேற தஸ்திகா. அதான் தஸ்திகா அந்த எக்ஸாமுக்கு சர்டன் கிரைட்டீரியா இருக்கு. இப்போ சுப்ரீம் கோர்ட்டுக்கு இத்தனை ஜூரிஸ்டிக்ஷன் உங்களோட ஆபீஸ் இருக்கான், இத்தனை வருஷம் உங்களுக்கு பிராக்டிஸ் இருக்கான், சர்டன் கண்டிஷன்ஸ் அதுக்கு அப்புறம் தான் உங்களுக்கு இது தர
foreign lawyers. So, if a foreign lawyer they cannot practice or they cannot allow. But if it is a corporate office and their head office in the US, so the CEO should some cases and maybe in the Nirmaya case, HP they call the CEO here, even he changed the different organization. So then he is eligible. Is he eligible to bring his advocate from US?
சொல்லலாம். எம்பி என்று லெக்சிகஸ் தெரியும். இட்டாலியன் மரைனர் அப்போ ஹைகோர்ட் பார்த்தேன். I was there. அப்போ இட்டலி இந்த லாயர்ஸ் ஆனா வேற வக்கீல் வரும், இவங்கள வக்கீல் நான் இட்டலிக்காரன். I will be discussing with him.
Okay. So the advocate should be appointed.
He will not. அவருக்கு எதுக்கு இந்த சில்லி கேஸ் பைசா கிடைக்கும். ஆனா we will discuss.
externally
Correct.
My senior CM Shamkumar sir.
these are paid.
He asked for they wanted to ask for 60,000 rupees. Simply asked for 2 crore. They gave them and அந்த ஆளு
హీరోని ఎదుగుతా కూడి
సంపాదించే
I think, sir, why it is black in color means black actually is not having any bias. In night, if you see gold or iron, it is same. So as it just jet, you know, it should be. Yeah, it should be. So it may be black in color.
See, that is some reciprocity. If we are allowed to practice in their country,
Thank you, sir.
Thank you, sir.
yeah, yeah, please.
Working, sir. Working.
It's also working.
No, sir.
This is only. Like, yeah, please do it now. Right. So yesterday we have seen different types of area. Yeah, please listen. Please listen. You are at the back end of your what is called completion of your course. Right? మనం யாராவது இருந்தா சம்பாதிக்கலாம். படிக்கலாம் வரும். யார் சொன்னது? அம்பேத்கர் இல்ல. தனுஷ் சொன்னான். தனுஷ்மா மாதிரி படிப்பு பணம் யாராவது எப்படியாவது வரும். படிப்பு என்னால வரும். படிப்புனாலதான் வரும். வரும். Please listen. Please listen. Replacement is learning here for you. Right? We have seen different types of area. In area, what is the adjudication order? Right? In area, adjudication order is the order. How it is binding on the parties. Award has been passed by a private person. Award has been passed by a private person, arbitrator. Then, how this award is binding means it's a consensual agreement. That means, whenever you are going for arbitration, in the agreement itself, you are writing that this award shall be final and binding. In agreement, arbitration போறோம் அந்த awards வந்து நாம follow பண்றோம். Right? Now, there are two forms of entering into arbitration agreements. Please listen. Two forms of entering into arbitration agreement. One is arbitration clause. Second one is compromise agreement. It is also known as submission agreement. This is the way in which we have to enter into arbitration clause. Right. First one is arbitration clause. Second one is submission agreement or compromise agreement. Right. First one is arbitration clause. Now, whenever you are forming the main agreement, main contract, in a main contract terms and conditions define பண்ணும்போதே என்ன பண்ணுவாங்க? If there is any dispute, we will go for arbitration clause. When you are going for arbitration clause, if any dispute arises, that means arbitration clause itself forms part of the main agreement. Whenever you are drafting the main clauses of the agreement itself, you are incorporating a arbitration clause. Whenever there is a dispute, we are going for arbitration clause. Lastly, we are going for arbitration clause. Right? This is also known as midnight clause. Midnight means at the back end. Midnight என்ன ராத்திரி 12 மணிக்கு என்ன சொல்லுவோம்? That is last day. So this clause is known as midnight clause. You know, in contracts there is one theory is there, no pencil theory. You know blue pencil theory in contracts. No. Whenever there is a dispute between two persons with respect to a contract, he will go to the courts. Now, how the courts are interpreting your contract by your intention. First thing is, you have to satisfy all essential elements of section 10. Section 10 elements you have to satisfy. Second thing, என்ன பண்ணணும்னா அவங்க இன்டென்ஷன் பார்க்கும் கோர்சஸ். What is your intention at the time of entering your contracts, right? If certain clauses are against section 10 and certain clauses are in consolation section 10, straight away the courts never repudiate your contract. ஒரு 10 கிளாஸ் இருக்கு கான்ட்ராக்ட்ல, அந்த 10 கிளாஸ்ல 5 கிளாஸ் வந்து இந்தியன் கான்ட்ராக்ட் பொதுவா இருக்கு. Remaining 5 clauses they are against the contract. Then the courts never cancel your contract in toto. It will take 5 clauses in the contract, it will enforce and it will give way to remaining 5 contracts. And the 5 clauses என்ன பண்ணணும் போட்டு இது enforce பண்ண முடியாதுன்னு சொல்லி பிரிச்சிடுவாங்க. பிரிச்சிட்டு எந்த terms and conditions இருக்கோ அத மாத்தி enforce பண்ணணும். That is known as blue pencil theory. Blue pencil theory. Likewise, it's a midnight clause. Fag end of your dispute. If any dispute arises, we will go to the arbitration. That means straight away you are incorporating the arbitration clause in the main terms and conditions of the contract. Right. This is first. Vindication later on. Second one is submission agreement. Once dispute arises after you are entering into an agreement, that we are going there. First contract dispute రావడానికి ముందే ఏం చేస్తారు? dispute వస్తే అక్కడికి వెళ్తాము అంటాం. సెకండ్ ఏమవుతుంది? dispute వచ్చిన తర్వాత then you are entering into a contract, arbitration agreement. Right. Now this is known as submission agreement or compromise agreement. Compromise agreement. Now there is one important aspect is there, how a jurisdiction is conferred on you. You know the meaning of jurisdiction, right? What is the meaning of jurisdiction? என்ன jurisdiction என்ன? அதெல்லாம் எந்த கோர்ட்டுக்கு போகணும்னு தெரியாது. We have to know the jurisdiction first. The court has power over the dispute matter. Normally in CPC, 3 types of jurisdiction is there. One is territorial jurisdiction, second one is pecuniary jurisdiction, third one is jurisdiction over subject matter. You know this. Territorial and the territory. For example, Tirupati problem in the Tirupati court. Who will confer this jurisdiction? State, right? State will confer the jurisdiction. Yaar decide பண்ணுவாங்க? State government, executive. For example, you are in Tirupati, you have entered into a contract in Tirupati. Now, if any dispute arises, which court you have to go? Tirupati court. Now, you have both agree, and you are telling each other that we go to Chennai court. Can it be so? No. That means you cannot confer jurisdiction or you cannot oust the jurisdiction. Your jurisdiction confer பண்ண முடியாது, jurisdiction even you cannot oust the jurisdiction. But on arbitration agreement, by consent of the parties, you can
No.
right. Now, what happens in main part of the contract? Either you cannot confer jurisdiction or you cannot oust the jurisdiction. But in an arbitration agreement, even though main part of the contract forms in Tirupati, if you both agree, you can confer jurisdiction in Chennai. You understand the difference between arbitration agreement and main part of the agreement. Cause of action is there. Over consent ద్వారా మీరు jurisdiction out చేయలేరు. But arbitration agreement you both agree. Even though the contract has been entered into Tirupati, you can make your arbitration agreements in Chennai. You can go. That means you can confer the jurisdiction of the agreements, arbitration agreement by your consent. Right. So this is the two forms in which you can enter into an arbitration agreement. One is arbitration clause. Second one is submission clause. Arbitration clause even before arising out of the disputes. Submission clause after the disputes has been aroused. Right. Now even from your intention also, courts will take out your intention whether you go for arbitration or not, from the intention of the parties also. So normally how this will be contained is a document signed by the parties. First way of entering into arbitration is a document signed by the parties. For a document irukum, both the parties will sign that document so that we are going for arbitration. Another mode of entering into these contracts is by exchange of letters also. Inga one person is posting a letter, நம்ம arbitration போலாமா? That person will tell yes போலாம். இப்போ ஒரு agreement இருக்கு அவங்க நடுவுல, is there any contract is there? No. But your intention is there. How? By exchange of letters. One person is asking that person whether we can go for arbitration. That person is telling yes. That means by the intention, your what is called your thing to go for arbitration is derived. Even telex, telegrams, other means of communication also, you can enter into arbitration agreement. Next one is in civil suits, what you are going to file first is plaint. Civil suit starts with plaint. Then here in arbitration agreements, first one is statement of claim. First arbitrator who is initiating the arbitration agreement is statement of claim. For example, two persons are there. A is there, B is there. There is a dispute between A and B. Dispute between A and B. Now, there is no arbitration agreement. A went to arbitrator, filed a statement of claim. A court arbitrator minna pona, statement of claim he has filed. Next one, opposite of statement of claim is statement of defense. In arbitration, statement of claim, other person will file statement of defense. Even though there is no intention on the part of that person, he will file statement of defense and he is not denying the statement of claim. అర్థమవుతుందా? ఒకతను వెళ్ళాడు ఆర్బిట్రేటర్ ముందు, స్టేట్మెంట్ ఆఫ్ క్లెయిమ్ ఫైల్ చేశాడు అగైనెస్ట్ బి. బి ఏం చేశాడు? దాన్ని డెనీ చేయకుండా he has filed statement of defense. Now he has not denied. If he denies, then the real thing starts. He has not denied. That means he has unconditionally accepted for arbitration agreement. Straight away you are filing statement of claim. That person has filed statement of defense without denying your dispute. That means here what happens? The initiation of arbitration starts. Next one is by reference to any document containing an arbitration clause. By reference to any document containing an arbitration clause. So these are the ways in which you can enter into arbitration agreements. Right. So now you have made an arbitration agreement. Now we are going to see the contents of arbitration agreement. Contents of arbitration agreement. So these are the terms of reference in which an arbitration agreement should invariably contain terms and conditions இருக்கும். கான்ட்ராக்ட்ல terms and conditions எப்படி இருக்குமோ ఆర్బిట్రేషన్లో కూడా terms and conditions అనేది ఉంటుంది. ఫస్ట్ వన్ ఈస్ ఎక్స్ప్రెషన్ ఆఫ్ క్లియర్ and unambiguous intention to arbitrate. Expression of clear and unambiguous intention to arbitrate. That means you are expressing your intention that you are going for arbitration. Subsequently, if an arbitrator passes an award, it shall be final and it shall be binding on you. Both the parties will bind for the award. మీరు అవార్డ్లో అగ్రిమెంట్లో ఎంటర్ అయ్యేటప్పుడు ఏం చెప్తారంటే, మేము ఆర్బిట్రేషన్కి వెళ్తాము, అతను పాస్ చేసిన అవార్డ్ని విల్ కన్సిడర్డ్ ఇట్ యాజ్ ఫైనల్ అండ్ బైండింగ్. సో ఇట్ షుడ్ బి క్లియర్లీ unambiguously expressed in the agreement. క్లియర్గా మెన్షన్ చేయాలి. ఫస్ట్ కండిషన్ ఈస్ expression of clear and unambiguous intention to arbitrate. Second one, scope of jurisdiction. Second one is scope of jurisdiction. Right. I have told you, you can confer jurisdiction with respect to arbitration agreement. Jurisdiction determines challenging of the award. Normally, award எப்பவுமே final and binding. You understand? Award cannot be appealed or award cannot be challenged except on certain specific grounds. You can challenge the award in the courts. Courts will set aside the award also. It does not mean that arbitral award is always final and binding. Still, there is a procedure for challenging under Arbitration Conciliation Act. ఎక్కడైతే అవార్డు పాస్ అయిందో ఆ ప్లేస్ is known as place of jurisdiction to challenge that award for setting aside that award. ஒரு வாட்டி ஆர்பிட்ரேட்டர் அவார்டு பாஸ் பண்ணா அதை நீங்க சேலஞ்ச் பண்ணலாமான்னா சேலஞ்ச் பண்ணலாம். only limited grounds are there. On the, for example, ground of fraud, you can challenge. So if the arbitral award has been obtained by playing fraud, you can challenge the same. Subsequently, award will be set aside. That means jurisdiction is very, very important. You have to mention where you are going for arbitration agreements or arbitration. Here, normally, even number of arbitrators will be there. ரெண்டு பேர் இருக்க மாட்டா, மூணு பேர், ஆட் நம்பர்ஸ், மூணு பேர் இருப்பா, அஞ்சு பேர் இருப்பா, 7 பேர் இருப்பா. You know why? If 2 members are there, if they equally divided, then in whose favor it has been gone? So normally arbitrator will be in odd numbers, 3, 5, 7. If there are more than 2 or 3 arbitrators, one person will be appointed as an umpire. UMPIRE. ரெண்டு பேர் arbitrator இருந்தா they themselves will appoint another arbitrator. He is known as an umpire. So if 2 persons divide equally, umpire will cast his vote in favor of one person. So that award is binding. Next one, choice of arbitrators. Third important ingredient which you have to incorporate in the agreement is choice of arbitrators. Right. That means if you know there are certain institutions for arbitration is there. Certain institutions are working in India. For example, recently our yesterday Chief Justice of India, Justice N.V. Ramana has opened International Arbitration Center in Hyderabad. ஒரு செப்பரேட் இன்ஸ்டிடியூஷன்ஸ் இருக்கும். அங்க போனோமா இல்ல நம்ம அப்பாயிண்ட் பண்ண ஆர்பிட்ரேட் கிட்டக்கு போறோமான்னு சொல்லி நீங்க மென்ஷன் பண்ணணும். Whether you are going for that institution for arbitration or you are going to appoint a private persons for arbitration. That you have to mention. What is the choice of arbitrators? What is the qualification required for arbitrator? For example, if it requires technical analysis, for example, big machinery இருக்கு. அந்த மிஷினரி இன்ஸ்டாலேஷன் பண்ணதுல ஏதாவது ப்ராப்ளம் இருக்கா இல்லையா, ஒரு ப்ராப்ளம் வந்தது அனுப்போ ஆர்பிட்ரேஷன் போனா அதை யார் டிசைட் பண்ணுவா? ஜட்ஜ் டிசைட் பண்ணுவானா? ஜட்ஜுக்கு தெரியாது. அப்ப யார் அப்பாயிண்ட் பண்ணணும்? டெக்னிக்கல் பர்சன் அப்பாயிண்ட் பண்ணணும். ஸோ டெக்னிக்கல் பர்சன் அப்பாயிண்ட் பண்ணாதான் அவனுக்கு என்ன ப்ராப்ளம் இருக்கு, இது இருக்கு இல்லைன்னு தெரியும். தட் மீன்ஸ் யூ ஹாவ் டு அப்பாயிண்ட் சாய்ஸ் ஆஃப் ஆர்பிட்ரேட்டர்ஸ். Next one is very important thing is choice of law, which is a governing law by which you are going for arbitration. Governing law. For example, American companies working in India. American companies working in India. Now there is a dispute between American company and Indian company with respect to certain things. இப்போ arbitration க்கு போனோம். Or if you want to go for arbitration, whether you are going to follow the American law or Indian law, that you have to clearly mention. எந்த சட்டம் பிரகாரம் நீங்க arbitration போனோம்னு சொல்லி clearly you have to mention in your arbitration agreement. Clearly you have to mention the choice of the law. So if you don't mention choice of the law, there will be ambiguity. Clearly mention cheyali which law you have to follow, whether you are going to follow that law or whether you are going to follow this law. Next one is choice of place of arbitration. Choice of place of arbitration. Right. This is very important. This is also known as venue of arbitration, where you are going to sit and arbitrate. Venue. எந்த பிளேஸ்ல வந்து நீங்க arbitration చేసుకోవాలని చెప్పి this is. Another thing is choice of rules. Choice of rules. Whether I have clearly told our Arbitration Conciliation Act is based on which model law? UN Citral model law. Now whether you are going for the rules of that model or you are going to frame your own rules. You are going to frame your own rules. So here choice of rules means how the procedure for initiating arbitral proceedings. First you have to mention the procedure for initiating arbitral proceedings. Next, method of dealing, how you are going to deal with this agreement. Then scope and limitation. Scope and limitation you have to mention in these agreements. Now, hearing procedures, notices and forms. Hearing procedures, why you are dealing with these procedures means, you know, arbitration is a private adjudicatory process to which there is no rigid formal requirements. CPC is not applicable. Evidence Act is not applicable. Then how you are going to adjudicate my dispute? You are forming certain procedures. CPC apply ஆகாது. எதுக்கு apply ஆகாது? Arbitration apply ஆகாது. Evidence Act apply ஆகாது. இதெல்லாம் apply ஆகாது. So without applying, how you are taking the evidences, how you are going to adjudicate the dispute. This you have to make rules. Next one is procedure for enforcement of awards. What is the procedure for enforcement of awards? You know, arbitration award is nothing but a deemed decree. என்ன deemed decree அண்ணா? What is the meaning of deemed decree? Huh? Yes, it is deemed to be a decree and you can go for enforcement. I think execution. அதை enforce பண்றதுக்கு you can go and where you are going to execute the arbitral award again in the district court. ఒక అవార్డు పాస్ అయిన తర్వాత అవతలి వ్యక్తి ఆ అవార్డుని ఫాలో చేయలేదు అనుకోండి, డిస్ట్రిక్ట్ కోర్టుకు వెళ్ళి యూ హ్యావ్ టు ఫైల్ ఎగ్జిక్యూషన్ ప్రొసీడింగ్స్ లైక్ హౌ యు ఆర్ గోయింగ్ టు ఎగ్జిక్యూట్ ఏ డిక్రీ. డిక్రీని ఎలా ఎన్ఫోర్స్ చేస్తామో అలానే మీరు ఎలా చేస్తారంటే ఎన్ఫోర్స్ చేస్తారు, లైక్ దిస్. అనదర్ థింగ్ ఈస్, లాస్ట్ వన్ ఈస్ choice of language. Choice of language, cost and currency of payment of the award. Choice of language, cost, currency of payment of the award. Currency, in which currency the award shall be enforced, right? Even cost also, cost, interest, how you are going, in which currency you have to pay the awards. So these terms should invariably find place in the arbitration agreement. Now you have entered into the agreement, arbitration proceedings is going on, till award has been passed or not, whether the court can interfere. Understand my question? Question puranjida? No. Courts can interfere after making the award, but before its enforcement, you can go and approach the courts for interim measures. What is the meaning of interim measures? In the middle. So you cannot oust the jurisdiction power of the civil courts. So, for example, arbitration proceedings has been over, an award has been passed in favor of B, one person. Award has been passed in favor of B. B died. B is having a minor son. இப்போ அவார்டு B's ஃபேவர்ல இருக்கு, Bக்கு வந்து ஒரு மைனர் சன் இருக்கான். இப்போ மைனர் சன் மீன்ஸ் A can misuse the award. At that time, you can go and file an interim application for interim measures. So first one is for the appointment of a guardian of a minor or a person of unsound mind. Appointment of a guardian of a minor or for unsound mind. It's a court's power to grant interim measures. Court can interfere. When it can interfere? Only after passing of the award, during the proceedings, or before execution or enforcement. After enforcement of the award, it becomes infructuous. Award చేసేసిన తర్వాత కోర్టుకి ఇంటర్ఫియర్ కావడానికి ఇంకేం ఉండదు. Something has been happened. Before happening, you have to come. Something has happened. After happening of the even if you come, I cannot do anything. Nothing but infructuous matter. So first aspect is appointment of a guardian or minor. Second one is for the interim measure of protection of anything under the arbitration. For example, preservation, interim custody of sale of goods, interim custody of sale of goods. You can go for arbitration under any applicable laws. Sale of goods కిందకి వెళ్ళొచ్చు, అక్కడ arbitration ఉంటే. For example, there is a dispute with respect to some goods. You have to protect those goods. So for interim protection of sale of certain goods, then securing the amount in dispute, ఈ అమౌంట్ మిస్యూజ్ కాకుండా బ్యాంకులో డిపాజిట్ చేయమని చెప్పి కోర్టులో you can go and ask. Next, detention, preservation, or inspection of any property or thing. Detection, prevention of any property or thing. Even you can go for interim injunction. You can go for interim injunction or appointment of a receiver. You can file a petition. Right. Now, when you go for arbitration means there are certain legal requirements are there. Legal requirements which is applicable for the dispute under which you are going for arbitration. For example, if you want to enter into a contract, section 10 condition should be satisfied. Now contract is there, arbitration agreement is there. Both operates in different arena. Main contract is invalid. Then whether arbitration agreement can be gone? Main contract is void. Then whether arbitration agreement is void or valid? It is also void. That means you should have certain what is called legal requirements. That means the main contract should be in consonance with Indian Contract Act. The main contract is void, subsequently arbitration agreement is also becomes void. There should be a defined legal relationship between the persons who enter into the arbitration agreement. Define legal relationships under the respective laws. Define legal relationship means person is a legal, corporation is a legal person, company is a legal person, corporation is a legal person. There should be a defined legal relationship. So you normally company is considered as an artificial legal person. Can company enter into arbitration? Yes. There is a defined legal relationship. Another important ingredient is there must be ad idem. Enna ad idem anna? Yes, identity of minds. Whenever you are entering into a contract, consensus ad idem. Next one is there should be intention on the part of the parties to enter into an arbitration agreements. Intention should be there. Then it should be a subject capable of arbitrable. Subject capable of arbitrable. Means what? Enna? Subject capable of arbitrable means only certain things can go for arbitration. Fraud, matrimonial disputes, insolvency disputes, இதெல்லாம் arbitration போக முடியுமான்னா முடியாது. You know why? Arbitration is in persona but not in rem, right? So these are the important ingredients whenever you are going for an arbitration agreement, right? So next class I am going dealing with arbitrator, different types of arbitrator and different types of awards, right? Got something today? Right. Good afternoon. How are you all? Okay. For a change, today I'm going to take international trade law, not in that. Okay. So I'm going to take international trade law now. Okay. Yesterday, I was asking you a question regarding ban dicta. In this matter considered as the international trade dispute, will it come under WTO? Yes or no? Why? Show me the evidence. There was an article published in the year 27/10/2020. The matter taken to WTO. Okay. China has given a complaint against India. Looked at violation of WTO rules and regulations. You know, India replied for that. Is the national security. So, okay. Sure. There shall I switch off this? So, so you know what India replied? It is because of national security reasons. It is a sovereignty and national security reason. Hence, India banned TikTok. The matter has taken to WTO, and WTO also dismissed that issue. Okay. So, hence, that case was considered as international trade dispute. Okay. Can anyone sum up yesterday's class? What is unicitral? What is unicitral? How many convention took place? 12. 12 or 11? I have given only 11, man. Okay. Tell me that year. కింద వినుందా? Huh? What is 1958 convention? Okay, 1974, 1978, 1980, 88. Very good. 91, 95, 2001, 2005. Very good. 2008. Okay, 2015, 2018, 12 conventions. Which year is missing? 2001. Yeah, take down. Convention on the assignment of receivables in international trade. Convention on the assignment of receivables in international trade, 2001. Okay. Today we will see what is meant by unitroid. UNITROIT. Acronym is unitroid. Okay. Unitroid, formally the International Institute for Unification of Private Law. Yesterday I told I sum up what is meant by unitroid. Unitroid is nothing but, for example, if India is Pakistan involves in export and import, there should be a unification of a private law, right? If some dispute arise between India and Pakistan, India cannot apply own rule, Indian rule, or Pakistan. So, unification of private law should be implemented in order to sort out the disputes between India and Pakistan. You got me? So, these principles, unitroid principles, plays a significant role in solving the international trade disputes. Okay, take down. Please take down. In my class, particularly, you must take notes because don't think uh, international law is easy because you have no case laws. It is purely based on theories. Okay, so please take note. The International Institute for Unification of Private Law, the International Institute for the Unification of Private Law is an intergovernmental organization, whose objective whose objective is to harmonize, the word harmonize means a peaceful trade between the member nation. Okay, the peaceful trade between member nation. You got me? That is the meaning of harmonize. Harmonize international private law across countries, through uniform rules. Very simple. Unitroid means, remember, unification. Okay, definitely you will be questioning either in part A or part B. Okay, unitroid. This question will be repeatedly asked. So put into mark unitroid. Don't talk. If you have any doubt, ask me. Please, my dear general students, please, I need your cooperation. Okay, don't disturb your friends. Let them take the notes. Okay, I'm really happy that today I could see the difference. You are maintaining your dignity and decorum. Seriously, I appreciate it. Okay. And the main objective of unitroid is, right on, the main objective of unitroid is to set the model laws. To set the model laws. Model law is nothing but, see, at this new era, the old law cannot be imposed in order to solve the trade disputes. Hence, the private law should be updated according to the new generations. Okay, so the unitroid sets new principles and new model laws. Okay, so take down, the main objective of unitroid is to set model laws, model, MODEL, model laws, and sets of principles and guidelines, sets of principles and guidelines. and the UNITROID has 63 member states, and the UNITROID has 63 member states. And the UNITROID, listen, don't take. And UNITROID is started in the year 1926. Okay, and they re-established in the year 1940. Till now, they successfully tackling all the problems in a amicable way. The UNITROID. So far, they have conducted 10 conventions. So far, take down. So far, the UNITROID conducted, yeah, conducted 10 conventions. 10 conventions. Take down the 10 conventions. Number 1, uniform law on the international sale of goods. The first convention is in UNITROID is uniform law on the international sale of goods in the year 1964. Okay, next one. Convention number 2. Uniform law on the formation of contracts. Uniform law on the formation of contracts. Contracts for international sale of goods. Same year, in the 1964. 1964. Convention number 3. International Convention on Travel Contracts. International Convention on Travel Contracts in the year 1970. Because of this contract, this convention, International Convention on Travel Contracts, because of this only we have a smoother international traveling. Otherwise, we have to face hell of problem. Because of these treaties, now we could able to have a smoother traveling between countries. Okay, anybody can lead a international travel after this treaty signed. You got me? Next, uniform law on the next convention. Convention number 4. Very good. You are alert. Uniform law in the form of international will. What is mean by international will? Generally, you know the meaning of will. What is mean by international will? International will. For example, a testator is writing a will in Australia. Okay, that should be executed in India. For example, A is having assets and bank accounts and shares, everything in Australia. Okay, a testator is writing a will. Now he has to give this to Indian citizen. Okay, so now the international will has to be executed without any without any trouble. Okay, after this treaty signed in the year 1973, by you can submit your passport and visa and along with the PAN card and some procurements. You can easily execute your international will without any interference. Okay, that is also a main important plus in this convention. Unit right, because of unit right principles. Okay, next. Convention number 5. Year 1973, 1973. Convention number 5. Convention on agency in the international sale of goods. Convention on agency in the international sale of goods in the year 1983. Convention on agency in the international sale of goods. 1983. Once you write, it will be remembered in your mind so that in exam time you can easily write. This is it's one of the best method of learning. Okay. Yes. Next, convention number 6. Convention on international financial leasing. See how many benefits because of UNITRIDE we are enjoying now. Convention on international financial leasing in the year 1988, which means anybody can transfer financial assistance to one country to other country. Okay. Convention on international financial leasing in the year 1988. 1988. The same year, another convention took place. That is, Convention on International Factoring. Factoring, FACTORING. The year 1988. Convention on International Factoring. The year 1988. So 7 conventions over, right? Another important convention, very, very important convention, which now we are executing it. Convention on stolen, convention on stolen or convention or stolen or illegally exported cultural objects. Convention on stolen or illegally exported cultural objects. Do you know the main plus of this convention? We could take back all our statues. You know, recently Queen Elizabeth passed away. Do you know in her crown, a diamond was the richest taken from our nation? Yes, Kohinoor diamond. Not it. Not it. But based on this convention, we can take back all our cultural objects. Year 1995. 1995. Now recently they have recovered a Natarajan statue from England. Yes, England, Australia, US. Our cultural objects are spread all over India. Sorry, all over world. I'm sorry, slip of my tongue. Sorry, last night I didn't sleep because of power cut. Okay, so our cultural objects spreaded all over world. Okay, now slowly after this convention, all the nations are supporting us to get back our cultural objects in the year 1995. Yes. Convention number 9. Convention on international interest Convention on international interest in mobile equipment. Convention on international interest in mobile equipment in the year 2001. That's why Foxconn, Apple, Samsung, all companies are started to invest in India because of this treaty. Okay. Once again, I'm saying Convention on International Interest in Mobile Equipment in the year 2001. Finally, only mobile equipment is. Final convention. Principles of principles of principles of international principles of international commercial contracts. Principles of international commercial contracts in the year 2016. Okay. How many conventions are there? 10. 1964. Okay. 1995. 1995. Yes, very good. 1973. International. Very good. Now, put the subtopic unification of international trade law. Unification of international trade law. Subtopic. There will be a question. Every country has some different legal system, right? Every country, obviously, every country has some different legal system. For example, if I want to investment in China, the legal system is entirely different. And the beauty of the part in China is China, Japan, and Korea. These countries, they never use other apps. For your information, Korean, China, and Japan, they never use other apps, applications. You know why? Yes, because they are very much concerned about their nation security. Seriously, you Google it, they never and ever use other countries' app. This issue also framed in World Trade Organization. This is also one of the major trade disputes. Through app, we can collect the data of citizens. Do you all know that? That was the main reason India banned TikTok, PUBG, and Hello. These were the reasons because there were no national security and protection in smartphone app. Okay. Now the substantial question is, uniform laws are essential for smooth functioning of world trade. Okay, as I quoted earlier, if there is a export and import between India and Pakistan or India and Sri Lanka, there should be a unification of law. Otherwise, as like Sri Lanka, we have to lose our economic zone. You are getting me? That was the main reason Sri Lanka lost their economy, completely dropped out, came to zero. Why Sri Lankan GDP, which means gross domestic product? You know why GDP level has gone to lower level? Because the domestic products stopped completely. They started to import things from China. Which means the rules imposed by WTO violated by China against Sri Lanka.
4 minutes షాప్ చేద్దాం మళ్ళీ టైం తీసుకోవాలి కదా
అవునా ఎవరు చెప్పినారు
12:30 షాప్ చేద్దాం
అదే
జాబ్ చేస్తాం
సరే
మళ్ళీ అయిపోయింది బే జనరల్ 4 రూమ్ నెంబర్
ఇప్పుడేనా ఒక 5 minutes
5 minutes తర్వాత చెప్పేసి పంపించాం
ఓకే ఓకే సో నౌ you are getting what is meant by international trade law. Don't confuse with private international law and public international law. This law is entirely different from public and private law. But some applicability will be there based on the nature of the case. Okay, you got me? And take the. Did you put that subtopic unification of international trade law? It's take down. The differences in legal system, among the various countries, the differences in the legal system among the various countries in the world are substantial, which means there's a big question mark whether it applies to all the nation or not. Yes or no? Yes. The differences in legal system among the various countries in the world are substantial. However, uniform laws are essential. However, uniform laws are essential for smooth functioning of world trade or global trade. For example, in case the dispute between exporter country and the importer country, okay, the question may arise to whose law shall prevail over the other. Yesterday we have discussed one case, footwear case between Indonesia and Argentina. Very good. Between Indonesia and Argentina. So where the dispute taken to? Where the dispute referred to? WTO. They have not approached their own domestic laws. Rather, they approached the matter to WTO. And World Trade Organization amicably settled down the disputes. Okay, that is why the UNITROID imposes unification of a private law in order to sort out the disputes. You got me? And take note. For example, in case the dispute between the exporter and importer
The dispute between the exporter and importer. Here the question may arise. Whose law shall prevail? Put question mark. Here the question arises. Whose law shall prevail? Big question mark. Try to give your own answer. Try to give your own answer and complete the sentence. Try to give your own answer. What would be the answer? Ah, yes, very simple. Implementation of unification of private law. Very simple. I'm repeatedly saying this because there should be a sustainable development in trade law, sustainable development in international trade law. Hence, unification of private law is mandatory. Okay, so within this, we'll wind up today's session. Happy weekend. See you all on Monday. Okay. So for your information, kindly listen to me. Please be seated. BA General, 5 years, fourth floor. Girls, listen to me. BA General, fourth floor, room number 2. You can leave. Girls, BA General, please move to fourth floor, room number 2. And for your information, you have class in the afternoon. That class will be taken by Subhamastu sir. Instead of my class, Subhamastu sir will be. Yes. Victimology and penology classes will be there. Please don't skip the class. It's very, very important class. Okay, you have class. Next. BA Honors, 5 years. Move to fourth floor, room number 5. BA Honors, 5 years. Kindly move to fourth floor, room number 5. Sultan. Next, BBA. Please move to fourth floor, room number 7. And BCom, fourth floor, room number 7. Sir, boys, final. And boys, BA General, 5 years. Move to fourth floor, room number 2. Boys, BA General, 5 years. Move to fourth floor, room number 2. BA Honors, 5 years. Move to fourth floor, room number 5. Please don't disturb others. BBA, move to fourth floor, room number 7. BBA and BCom. BBA and BCom, move to fourth floor, room number 7. Please don't go.
Serial number serial number by serial data. No, it's okay. You saw. Sir, listen to me 1 second. Creates gender. Register number 1 to 10. 1 to 10. Which your gender? Please go there.